Probably.
Ladies and gentlemen, we are ready. Good evening and welcome to the PBZBA meeting. Tonight is December 17th, 7 p.m., and I would like to call the meeting to order. We'll begin with the Pledge of Allegiance. I
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. We do have a quorum. We have 4 members that are absent. That would be Mr. Terrell, Mr. Cronin, Mr. Nolan, and Mr. Sinklew. Mr. Cronin is here. I'm sorry. Mr. Terrell, Mr. Nolan, and Mr. Sinklew. 3 members absent. Perfect. We have no public hearings. Our minutes, I told the town board, our minutes, we have no minutes that are on record yet. So when we didn't have video recording last meeting either, so it was double whammy there. I went home and typed something up briefly that I just want to go over. So Linda, we started our meeting. All members were present last week except for Mr. Boomer, yourself, and Mr. Shemaleski.
Thank you.
The meeting was called in order at 7 p.m. We approved the minutes from our previous meeting, and Mr. Cronin made that motion, and it was seconded by Mr. Collins. There was no new business to be addressed. We did have Mr. and Mrs. Dorsey were here. They were here to speak on behalf of 880 Bridge Street. I did state to them that the board doesn't usually have people speak unless they have an application or a permit. We were allowing them to come if they had anything new. It was stated that they had no new information and the board can't act on anything or do anything. Mr. and Mrs. Dorsey did approach the podium. They handed out materials to the members. I did state to them that we acted on a recent application based on facts and evidence presented to the board. Mr. Collins did ask Mr. Dorsey 3 times if they planned on having the property used for weddings, and there was no answer. Mr. Dorsey presented information that was given to the building inspector. We couldn't really speak on that behalf because Mr. Shemaleski was not here. I advised the Dorseys to continue reaching out to the town board and to the building inspector for further help. Does anyone want to add anything more to that section? Okay. We then moved to the site plan review of the Queens PV. Jeremy informed the board of new information in reference to the Albany City Water Board. The information was presented to us. They found there was a deed, and it was presented by their counsel from Snyder and Snyder, letting us know that the landowner has rights as far as on this Albany City. We wanted to get this in writing, and Mr. McGuire recommended that the board be given a copy of the map to show this. And it was Mr. Sinklew that stated we wanted that in writing. Anything else on that? I asked the board if we were ready to act on that application, and all members agreed. I read 26 conditions that would be applied to both site plan and special use permit. No, we added 2, right? So we started with 26 and then we added 2 at the end. 2 conditions were added based on Mr. Sinklew and Mr. McGuire's questions. Council to Queens PV questioned condition 6, which was in regard to the CPI in reference to the money that we will be taking for the decommissioning plan. And we all agreed that we wanted to continue that. It was past practice that we've done that. And Jeremy did agree to that condition at the meeting. I made a motion to accept those conditions. That motion was seconded by Mr. McGuire. I then followed by making a motion to approve the site plan for that Queens PV. And that motion with 28 conditions now. And that was seconded by Mr. McGuire, and all members voted in favor of that. I then made a motion to approve the special use permit with 28 conditions. And again, this is the same property and applicant. That was seconded by Mr. McGuire, and again, all members were in favor. I asked the planning board if they would support moving the PBZBA meetings to the first and third Thursday of every month for the 2026 calendar year. Council was going to get back to us. I then introduced a local law and a proposition that the town board presented at one of their meetings. I informed the board that it was recommended by the town board to present this to the PBZBA and discuss the items so the town board could possibly have a workshop with council also being present. I then recused myself due to being a town council member in the future. That would be on the flip side of this. Mr. Collins was asked to chair this topic. He recused himself due to having property that is being affected by this. Mr. McGuire agreed to chair for this topic. Council advised the board to read both the local law and the proposition and to use their experience and knowledge to consider these items. The board plans on discussing it further in greater detail at tonight's meeting. Mr. Collins wanted read into the minutes for public record that he did not advise Mr. or Mrs. Dorsey that he would have voted yes on the application as stated in their email to the board. He wanted it stated that he advised them to fill out the use variance and they may have a chance. And then there was a motion made to end the meeting by myself and seconded by Mr. Collins. Is there anything any member would like to add?
I think for the Clemens PV, you provided an update on the ground penetrating radar, and there was some discussion maybe at length about that condition.
Yes, there was.
They were gonna see what it cost to do the fence, because if you moved it 50 feet, it was gonna cause their outlay.
Correct. Their civil map would have had to be changed,
Correct.
would have been changed. So in one of the conditions, we gave them the option. They can have the GPR done or move it 50 feet. So that is ultimately going to be up to them. And yes, that was discussed. Thank you. Anything else discussed? That's important for those minutes. Okay. Okay. So that was a recap of our that was our December 8th meeting. No new business. So I have a couple things that I want to go before we jump into that proposed local law. One is, we just went over the minutes, talking about changing the meeting. We went over that. I'm going to sort of jump here. For the past year, I've been talking at great detail with Bill Kinnery, and I spoke with Andrew today about it. Our agenda. And Jason, you're not going to like it, but we're going to talk about it. Andrew was under the assumption that that the old business being the site plan review for Lois Realty is on the agenda. It's not. I've asked you, and I know Bill has advised it, on our agenda, can we just have what we're discussing at the meeting? Old business, either have, I don't even care if you put it on the back to keep for your own running records, but if you think about it, the public who sees our agenda notes, they think that may be discussed, and it's not. So if we can just remove old business and just have call to order, approval of the minutes, and tonight's business, or just so it's clearer and there's no misrepresentation that there's, and I just want the board's input on that.
What's the reason you put it on there for?
That it does not get lost track. There is an application in front of you right now, and it was new business, and that's how it starts.
Yeah.
Until it gets approved, then it comes off the agenda.
I see Mr. Morgan's point. You know, the last meeting and this meeting, I had expected Lois really to be here to talk about their application last meeting and this meeting, and
Correct.
so
And
it is confusing even for board members who are generally more involved with this than the public. So I think the casual observer would find it confusing. I don't know if we could put it below that line that has the next date or the date of the next meeting or on the back as suggested by the chair. That might help make it a little bit clearer for most people.
And maybe you could just mark it as like inactive while keeping it under old business, something like that, just so it stays on the table, but there is like some indication. Yeah.
Yes.
You know,
But it's really not on the table for us,
it's
it's
not.
on the table for you, right? So,
No, it's on the table for you. Because he came in and presented like he had to, and he is working on his maps because I had communications with him yesterday. And he is almost done.
right. But we're not gonna see him until he gets done.
Correct.
Then it should go back on. So really, it's only for you right then until we get something presented in front of us.
I think if we accept the application, though, it's ongoing business before this body. You know, maybe that's the step, right? The
Yep.
application acceptance.
Okay.
I wonder if we could just clear it up and put tonight's business. Or just to really, or if you make this 2 pages and keep your running stuff on the back, but just make visible to the public what we're going to be discussing tonight, just so it's not confusing to them and to some of the board members.
Or if we could put like a, change like the header, and put like items to be discussed or matter or something like that, so that it's clear that this is what's gonna be discussed, this is old business, whatever, but I don't know.
And if I may, from our perspective, generally the agenda is setting what the board will be discussing this present night. Now, that it's not wrong to do it this way, but I initially was confused by it, so I think that suggestion about different headers is practical. We've seen that in other municipalities to make it distinct as to what is on the board's agenda versus what are active applications before it, regardless of what stage they're at. So there's a clear public notice of what is being discussed and overall what is before the board, just from our point of view.
So I'm just bringing that up. However you want to work that or tweak that. I mean, after tonight, I'm not it. But I did want to bring it up because it has been something that's come up multiple times. So I'm bringing that up again. The next thing to discuss, I don't think there's really anything. We do have to move on to, at our last meeting, I was asked to discuss the proposition of that local law, the proposed local law, and the proposition that they presented. But I was also asked to present to you to consider, discuss the possibility of unmerging the Planning and Zoning Board and going back to 2 boards. I do not feel comfortable talking about that because, again, I'm going to be on the other side that may have to act on that. So I'll recuse myself from any discussion with that, but I leave that with the 4 of you to discuss.
Did they, do you know does anyone know if the town, if they have a reason, like what was their explanation for wanting to split it up?
I can add to that. Their reasoning was ethical. Sometimes if you act on something on the planning side, but then there's a zoning issue, if it ever went to litigation or anything, and maybe Andrew can speak more of that, but that was one thing that was given.
Okay.
You know, I don't want to give my 2 cents, but that was one of the reasons.
What's your take?
Well, generally that could be a concern, but procedurally, if there's a zoning and a planning issue, it'd have to go through the zoning side first, assuming that a variance or something of that nature is required. But generally, the New York State Advisory Committee on Open Governments, they advise against merging the boards, but after it's already merged, they don't really provide any guidance. And I have seen guidance where in favor of a merged board, there are considerations of saving municipal resources, being more effective as a board. It really comes down to the individual community, and you all know the community better than any outsiders do. And it deals with the frequency of the meetings and the likelihood that members would have to recuse from applications. One of the concerns cited is if there is a joint board and a majority of members had to recuse from a planning or zoning issue, then there'd be no board to be able to discuss it, and you'd have to look into potentially bringing in new alternates. But I'm not sure what difficulties this board has faced by being a combined board, if any.
I don't think we have, to my knowledge, had any kind of difficulties resulting from the boards being merged. I know originally the reason that was given for merging the boards was to try and speed up the approval process and that's also why they wanted, I think that's also why we went to 2 meetings a month. Because when we merged, then it would make things go faster. So maybe that's not a concern anymore. I don't know.
Just generally following up on that train of thought, if the board were to be split, would it be 1 planning and 1 zoning meeting per month, or would it be 2 planning meetings and 2 zoning meetings a month? I'm not sure of the
I
logistics.
don't know.
Question.
There would be a five-member board or 7-member boards.
Right.
They have to be 5 unless they're merged, right?
Is it 5
Unless
they go.
up to
Planning board used to be
Town
5.
laws.
You only have 5 members.
Generally starts at 5, it can be increased to 7. Now, I can't say I've seen a situation where a merged board has been separated and what the total members would be. That would get worked out through any town local law, separating the boards and appointing new members, obviously.
Mr. Collins, you've been on the board probably the longest and had time on before it was a separate planning board and zoning board. Do you feel that the applications now are working through the board at a quicker, faster than what they had been historically? Has there been a market
Well,
difference?
we do a lot more planning than we do
Zoning.
zoning.
Right.
That's sort of my thought, that a standalone zoning board would not, I'm not sure if it'd have enough business to justify its own existence.
Sometimes we went 6 months without them
Right.
even having a meeting,
Right.
because nothing was on it.
Yeah, that was my recollection from the previous tenure was that the ZBA would meet infrequently, and it was only if there was a referral to them. And that, in the last year, how many zoning applications have we had, right? We had a couple, but we had more this year than, we had more this year than I think we have in the past, but there were some other issues there. But
Right, because lately all it's been is site plan review with a special use permit
Right.
on countless.
Yeah.
You know, the only zoning would be subdivision. That would be zoning.
What was?
A subdivision would be zoning. Special use permits would be zoning.
those are really,
I think you said subdivision would be planning,
Planning?
and zoning would be where a variance or, I'm not sure, I think this town special use permits are zoning. I am not overly familiar with the code.
Yes.
Generally, zonings are when something's not allowed by the code and you need some relief. Planning is a subdivision site plan, typically.
I mean, I think in the abstract, just, based on some of the precedents you were citing, in a bigger town where there are a lot more business, I think there's probably, at least in my mind, more justification for having different boards. But, I mean, if the zoning board is only meeting, twice a year or somewhere in that ballpark, I don't really know if that's enough business for the town to create a separate board, if that makes sense.
Yeah, it makes sense to me.
I mean, I look at it that if you have a board that's specialized, one with zoning, one with planning, it does provide the opportunity for the town to have members that might be a little bit more familiar with those different areas, where I think we've kind of become jacks of all trades in planning and zoning. And if you have a separate board that's constituted of just members for zoning or planning, they might be a little more specialized. Now, that being said, you also have to, staff that board, so you have to find other people that may have that experience, and Queens being a relatively smaller town, that expertise may not exist, but I think it does provide that opportunity for the town to get more specialized points of view and maybe a little more diverse points of view on the different boards too.
Well, they don't have to, have to have some kind of school.
Yeah.
We gotta have school.
Yeah.
4 hours a year.
Right.
Makes us experts.
No expert, no, sir, that's what council's for.
Yeah, but I guess really, at the end of the day, it's kind of up to the discretion of whatever the incoming town board
Correct.
wants to do. I suppose they could consider all the things that we talked about this evening, and,
But to answer Andrew's question, I don't know about the one meeting for the month for the planning. I believe it was 1 month, one meeting a month.
I thought it was.
If I remember correctly.
Yeah.
And then it was only a zoning meeting if they had something on the agenda.
On an as needed
Yeah,
basis.
right,
And that-
correct.
That's what we see in some other more rural communities where the zoning board is infrequent, only when matters are referred to it or come up. whenever.
My thought would be to defer it to the town board, but if the town board does decide to separate the boards, I think my personal recommendation would be that the planning board continues to meet 2 times a month.
I agree with that.
But now you gotta fit
Yep.
What day would you put the zoning if they had
It
to
could
meet?
be the third Thursday starting at 8:30. But I think that having 2 meetings a month does help move the applications along, right? And it makes sense. So,
Actually, it makes the meetings a little shorter sometimes.
and I will say that when we've had no agendas, we cancel meetings, right?
Yeah.
So if there's nothing on the agenda, then we, that same would be true for the zoning board.
And we do run into, it does speed it up, I agree. I do think sometimes we run into issues anyways because the county only meets once a month, so it kind of takes away from us meeting twice, but it is good to keep the discussion going, and especially when there's things that we ask the applicants to come back to us with,
Right.
it helps to speed that up, because otherwise now come back in a month, whereas at least now it's, come back in a few weeks, so that's definitely something to consider too.
So you heard our discussion, so you
I
can
heard your
take that back to
discussion.
the
No,
board.
I'm going to email them tonight and let them know to watch tonight's meeting. Because it's being recorded, right, Bill? So they can watch it and get this update, but I will fill them in. So thank you for discussing that. The next thing to discuss is the proposed local law and then the proposition that was put forth. So before I am going to recuse myself. I'm going to continue to be recused from that. Before I do so, I just wanted to, did you get a copy of all of this?
No.
Okay, so this, I believe, was the resolution that was presented. And then this was, I may not have it. Here it is. This is the proposed local law. And then I gave this to everyone at the last meeting. This was the background information to how this proposed terminal local law came about. And this is the background information to the site plan review that they did. So, Mr. McGuire, I am going to ask you if you don't mind continuing just leading this.
Sure.
Because Mr. Boomer was not here at the last meeting. And
Which one are you doing, the terminal or the
that's
site
up to
plan?
Mr. McGuire right now.
So we could have a discussion even if we don't have a quorum, right? Because if Mr. Collins.
I'll stay in for the site plan, but I'll
I'll
recuse myself for the.
Right, you can't take final action.
just
without a-
want to make sure we're all, okay.
So I'm gonna recuse myself on both matters.
Mr. Collins, I'm sorry, which one did you say that you?
The site plan I'll stay on
Okay,
for.
well, we can start with the site plan then. So the,
You're fine.
Did you get a copy? You got a copy?
Yeah,
of
I
this?
have a copy right here.
So sorry, forgive me. Site plan,
You got some money tonight.
what's that?
Lucky you got some money tonight.
Oh, yeah. Okay. Okay. The resolution, which is right here. Yeah, that's not site plan review law. So, the November 13th meeting of the town board, there was a resolution that was up for consideration, which was not acted upon. And if I have any of the facts wrong, please feel free to step in and correct me. But the proposed resolution was to clarify the historical language that was within the town's regulations, specifically the site plan review law, and industrial uses. It was looking at section 136 of the town law. The intention of the resolution was to clarify that industrial uses, industrial zones would also be subject to site plan review. The historical interpretation of our zoning regulations have said that approved uses within the industrial zone do not require site plan review. And it is from what I can tell, the opinion of the town board that that is contrary to what is within the town law. That the zoning guideline contradicts what's actually in the town law. And that's where we have this proposed resolution that's before us. And I think everybody has had the opportunity to read the resolution. Maybe get the reso if you.
Oh, yeah, I got it.
Okay. Does anybody have anything they'd like to add? Did I miss anything? Forgive me if I did. Andrew, I don't know if you read all of this, or if you have
I
anything.
have been through it and I watched the previous
Yeah.
town board meetings, so if any legal questions come up, I should be prepared for you all.
Just sort of as an operational question, this remains an informal discussion, I would think, because the town board hasn't actually started the clock.
Yes, Mr. Cronin, I did reach out, thank you, to the town board to ask, one of the items that they were talking about was having a joint meeting between the town board and the planning board, zoning board of appeals. I emailed the town board and they were going to get back to us with some proposed dates for a joint workshop. So I think the purpose here is to just discuss, see if we have anything else we want to add to that discussion now as part of our board. And once we hear back with the actual dates, then we can try to figure that out. But at this point, we're probably looking at some point in January.
And just generally, if you want a little input from our point of view, maybe go over why this is even coming to the joint board here. That's because the town code requires it to do so. So this board is supposed to render an advisory report on these proposed revisions. And frankly, the code does not limit what may be put in your advisory report. You can touch on any areas you deem relevant of the revisions. However, the code does require or mandate that the board shall only favorably recommend adoption of proposed revision if the following conditions are met. A, the revisions are not contrary to the general purpose and intent of the chapter, and B, the revisions are accordant with the comprehensive master plan. So those are your general guiding principles when looking at these revisions, and obviously no need to answer those questions in the affirmative or negative right now, but just something to keep in the back of your minds while you discuss these revisions generally.
Andrew, is that guidance found within law? Are they pulling that from? Or is that,
That's in Let me see, it's in your code.
Okay.
Section 165-15B.
165.15.
15D?
B, sorry.
Now, this was due to column 18 in the schedule of the districts, right? For industrial.
I believe so. That's what's in this historic material provided.
Right, because it says for, in column 18, under the industrial zone, required site plan review and approval by Planning and Zoning Board of Appeals for all except principal uses.
What'd you say? All?
For all except
Principal uses.
principal uses. My understanding is that they wanted to change that column for all uses. Correct?
I believe that's the intent of the revision here, where all industrial principal, and excuse me if I'm speaking as familiar as you all are, but the intent is to require all these uses have site plan review by this board.
Is it known how the all except principal uses language entered the schedule if it's not in accordance with, what is that, 136 site plan review law?
My understanding is that predates the other town
That law.
laws. So that zoning schedule is coming back from 60s, which
61, 62.
Mr. Collins was here around, but the rest of us, I'm not too sure, so. Not that, I'm not saying that you had a hand on that, but Mr. Collins, but.
So it was just if the regulation was not changed at the time of the adoption of the site plan review.
Correct. And then the interpretation was that the zoning, the language in column 18 superseded the site plan review law.
Well, I don't.
Where did that,
Well,
how,
I think, again, reading the discussion, I believe that was what, if I'm wrong, tell me I'm wrong, please do. But my understanding was that in the background of the site plan review discussion, it talked about how originally the site plan review law went in. The thought was that it would cover everything, all uses and everything. It would have to be site plan except what's residential, single-family homes. But then it was interpreted that that language within column 18 said that there was no need for site plan review for industrial primary uses.
So if somebody has a company in a building and they want to move out and move somebody else in, does that have to be site plan?
Good question. I'll give you an answer in a second. Well, it depends on, there is, if it was a change of, I gotta find it. I'm looking, I'll give you an answer in a second. Mr.
In the industrial zone, I mean.
In industrial
I mean,
zone,
it's-
right here. Let's see, so it is 136-4. Site plan review shall also be required for the resumption of any use discontinued or not used for more than a year, or for the expansion of any existing use. Expansion shall include a floor space increase of 25% or more within 1 year period, or an introduction of new materials or processes not previously associated with the existing building. So your answer would be yes.
It's an existing use moving to a new building.
Yeah, but
Yeah.
if they do it less than a year, it's okay. But I said more than 1 year.
Right, or the introduction of new materials or process. not previously associated with the existing use.
Could you repeat your question again? Sorry.
Say you have.
Is the question, when would a site plan review be required for an
Yeah.
existing use?
In industrial zone, right?
Okay. Based on the current code or the to be, or the amended proposal here?
Current code right now.
So that comes from that code section you just read, where if the use ceases for a year or if the use expands in a degree?
Yes.
Okay.
Or introduces new material or a process not previously associated with the existing use.
So basically, if they're exceeding the threshold they're operating at right now, then that would be a basis to require site plan review? Or if the cessation for a period of more than a year?
I think historically that has not happened, right? Because I think the one example that we could point to would be the Port of Queens.
Right.
And where it ceased operation for a number of years, right? And you may know the details more than I do of the timeline here, but I believe it was purchased by Carver and Industries, right? And then at that point, they started operations again, and it went from P&M Brick to Carver, right? Industrial use with industrial zone, but my understanding is that operation did not go through site plan review when that happened, right? So we did have an instance where the permitted use within the industrial zone was lying vacant for more than a year, right? And section 136 would indicate that it should have gone through, depending on how you read it, right? 136 would say that it would go through site plan review because it stopped operation for that period of time, as mentioned, and it was also a change
So
in the
when
use.
you first bought it, it didn't go through that 20 years ago?
Do you know?
Not to my knowledge. I've only been here for 5 years, and
If I recall, Mr. Collins, I don't believe that it went through site plan review. Now, I may be wrong, I wasn't on the board 20 years ago, but from what I remember, past discussions outside of this board, when it was converted to the port, there was no site plan review process that was done. And I don't mean to isolate that as an example, but that's probably the most pertinent example that we would have as far as industrial operations go. And at the time when that happened, again, this is my understanding, that our code enforcement interpreted that line on column 18 as saying that it did not need to go through site plan review because the principal uses that were going into the port were identified as principal use within the industrial zone. And it would seem to contradict what's in section 136.
Yeah, I guess that was my question, because I didn't see in the narrative here the exact timeframe of that interpretation. So,
And generally, when there's conflicting, sections in a code, these ambiguities and conflictions are resolved in favor of the property owner and construed against the municipality because they are the one who adopted it. So that might make sense as to why the code enforcement officer at the time said not required.
Yeah, because just new law, they want to go back, be able to go back 15 years. And I don't believe that is right.
So, well, so this is a resolution, right? So it's not a law, right? So,
Right.
but,
let's just say, I sort of view it as two components. I view it as the zoning schedule change and then how they want to enforce that. So on the resolution, it's, item number 1 as opposed to 2 and 3, and I guess 4 also. Personally, I think there's, a lot of merit to fixing the schedule, but I'm really not sure about, as you say, the enforcement component of that, right?
I mean, maybe going forward, but I don't see it's fair to go back.
Yeah, and I think, my reasoning was I think that pretty much we're putting a failure of the town on the property owners, and I don't know if that's just, but I'm not sure if that's legally wise to pursue. I think I had a second point, but I forgot what it was.
And just very generally on that retroactive enforcement point you're touching on, that is a valid argument. I don't know the specific cases. It would have to be looked at on a case-by-case basis because these are constitutional arguments where people
Right.
or property owners would say they have a vested right based upon previous approvals granted by the town. So I think you're correct in breaking that into the enforcement versus the planning requirement of site plan review. And that could be distinguished in this board's upcoming discussion, the joint meeting, because that is a practical consideration. And it frankly would be on a case-by-case basis when you can retroactively enforce the zoning.
Right.
I tend to agree with you that it looks like we're looking at two different things here, right? The fair application going forward and the retroactive look back, which, again, through no fault of the property owners, they were acting based upon the best guidance and information provided by the town at that point in time.
I also just think programmatically it creates sort of a burden on this board to.
4 meetings,
So-
4 meetings a month.
So we're on the industrial zoning. So that's- Say one of them buildings that he rents out now, somebody moves out and somebody wants to move in. Does he need a site plan review?
So currently, based upon that, again, my opinion, maybe we have interpretation, but I don't believe there is no site plan review now, right? If we have a change in tenancy or use of that building,
Right.
which I think we've seen. in
We've
some-
never done a site plan review whenever any business
Right.
in the industrial park moves.
Andrew, from your experience, is hypothetical situation here, if we're looking at a port facility that's not in Queens, but can be in any town, and you have a site plan review and that approves the variety of uses, if they're changing tenants, does it have to be reviewed whenever somebody else is coming in, or would it be?
So when you're doing a large-scale site plan review, just from experience, you might not always be looking at the individual tenants, but you'll be looking at, say, different buildings in the site that will be for some category of uses. And the threshold for amending your site plan approval or revising it is whether it's substantially differing in any way. Is the use going from level A going up by double or something like that? Now, that is also something that this board could consider, because I think, if I'm reading this correctly, part of the intent is to get a grasp on what the uses are in the general area. And if the board were to also look at what triggers a site plan review and like a change of tenancy or a change of use, that would be a potential method to get more places subject to the site plan review without retroactively enforcing it. So to answer your question, it's not a hard and fast rule as to, yes, site plan review would be required for a change or no. It's really a discretionary determination unless provided for expressly in the code. But if the use is greatly increasing or substantially changing,
Who's would make the decision whether that change of use has to come before the planning board?
well, what happens for a change of use in this municipality? Do they go to the building department? I think that would be the first initial determination.
Yes.
So from your department, then you would say you need to go get
Right.
site plan approval.
Yes.
All right. Well,
I agree with Mr. Collins. I'm not necessarily against having a resolution to align and clean up our current zoning.
Yep.
But I don't think it's reasonable to go back 15 years and then require businesses to apply for a site plan with something that's already done. That I don't know. I don't agree with that either.
Just a nitpick for my day job. I watch all the meetings, so I understand what they mean, but directs that to avoid confusion, concerning the zoning code that a clean version of Schedule F be prepared. I think that should be a little more specific.
So, yeah, I had one question about that too, and I'm wondering if a clean version of Schedule F, it would depend on what one's definition of a clean version is. My opinion might be that clean version if you're removing that information from column 18, right? But then at that point, that's a change in the zoning schedule. And would that require a local law? Or can a resolution make changes to our zoning schedule?
I know that point was raised before the town board, and I know the town board has counsel, so I will defer to their.
Defer to council, that's.
But I do think that is a point that should be brought up,
Okay.
because I think that equivalency doctrine might have been touched upon. That is where, when something is done, be it one method, be it local law or resolution, it's typically followed.
Yeah.
But defer to the town board's counsel.
Okay, so. Any other comments, concerns, questions? I think maybe we continue to digest it. We can recommend that the members who were not here tonight watch tonight's discussion and then be prepared.
You got one question that you didn't get answered, Andrew. When you first started, you said, who wanted to change this law? Nobody gave you an answer. I don't know. Did anybody come see you about this law?
I've had discussions.
The board member?
No.
That's all I got.
All right, well, thank you, all right. So we don't have anything else to just add to the discussion of the site plan review. We can move to the transportation terminals.
I'll excuse myself from that. Because it directs to me. Even though I do have an open mind about it. I think it's in their best interest. I'll sit out.
And just to be clear, based upon the additional recusal, will be at 3, so the board's still free to discuss this, but no official action can be taken.
Do I have a copy of that local law? I'm always got trying to find
I think it
it.
was in the same
There it is.
resolution.
And it's for proposed local law. So, proposed local law for the year 2025. Does anyone have a copy of the draft law? Would it help if we read the item, or do we not? Yeah, you probably can't, right? So, the purpose of the local law, the purpose is, and subject to local laws, to amend the Town of Queens Code, Chapter 165 zoning, and to add a new definition for agricultural-related transportation terminal, and to clarify that such an agriculture-related transportation terminal is permitted as an accessory use in the residential and agriculture RA district, while a transportation terminal, as it is currently defined, is not. The intent of the local law is to clarify and correct an error that was made when local law number 9 for 2020 was enacted and added the definition for transportation terminal to Chapter 165 zoning without distinguishing between the transportation terminal as an accessory use in the residential and agricultural district and a transportation terminal as a principal use in the industrial districts. Authority, the town Board of the Town of Queens as legislative body for the Town of Queens hereby enacts this local law pursuant to authority confirmed to it under New York State Town Law Article 16, the New York State Municipal Home Rule Law, and the New York State Constitution. The legislative intent. The intent of this local law is to clarify the zoning code by establishing and defining the term agriculture-related transportation terminal, and to add that use as an accessory use within the residential and agriculture RA district, while limiting the current transportation terminal. And then the local law goes on, Section 1, Chapter 165.3 of the Code of the Town of Queens is hereby amended to add the definition of agriculture-related transportation terminal as follows. 165 sub 3 definitions. Transportation terminal, agriculture related means a yard or transfer site used for the storage and or transfer of agricultural related produce, goods, or materials that are grown, cultivated, harvested, or produced as a result of the permitted principal use within the residential agricultural district. Section 2, Section 165, Article 5, Schedule of District Zoning Regulations shall be amended to I, remove transportation terminal as accessory use in the residential and agricultural RA zoning district. And I, add a new definition as adding the newly defined agricultural related transportation terminal as an accessory use in the residential and agricultural zoning district. And the rest goes on from there, so. All right, so the proposed local law would be adding the agricultural related transportation terminal to the definitions and removing the transportation terminal as an accessory use in the residential agricultural district. Right. If you find the definition. It's 165.3, right? Good. And in the existing town law, 165, sub 3 definitions, transportation terminal is defined as a railway terminal, freight station, container terminal or yard, multi-purpose cargo terminal, port, transfer station, or any similar receiving point. So, okay. Thoughts?
So again, how would this, I don't see where it really addresses it in the proposed law. But is this gonna be retroactive, or is this for any new?
So, Counselor, correct me if I'm wrong here. The effective date, it becomes effective immediately upon filing with the New York State Secretary of State. So typically, unless it's identified within the local law, it would be effective as the date of filing going forward, right? But there's no retroactivity to that.
Correct. Unless there's something explicitly stating this retroactively applies or something to that effect, then it would potentially create some pre-existing non-conforming uses, meaning any of the ones meeting the old definition that are no longer in compliance upon adoption.
If there are instances where it's non-compliant use upon adoption, they would continue to be grandfathered in under the previous permission, right? And then
until there's a substantial change or something to that effect that would make them lose that status.
I think we're all pretty familiar with our zoning codes and the principal uses, but generally speaking, our residential agricultural properties, our principal uses would include anything in R2, which would be multifamily residences, seasonal cottages, general farming, cultural facilities, recreational facilities, reforestation areas, day camps, riding academies, public utility facilities, market gardening. So this and the existing accessory uses within the RA zone, all uses permitted in R3, roadside stands, barns and outbuildings, professional offices, farm produce warehouse, barn, and transportation terminal. So that's where our transportation terminal fits in there, is within there.
Yeah, the draft I have has that transportation terminal agricultural related definition in there. Is that the current draft? The reason I ask is because the narrative talks about owner-occupied contractor yard, which doesn't actually seem to appear in the draft.
Mr. Crone, as far as I know, this is the most recent proposed draft, and I don't see anything in there either for that owner-occupied contractor yard. Do you know if there was any additional information about the owner-occupied contractor yard?
Yeah, where was that one sheet you were gonna?
So, within here, based on those concerns, the town attorney is prepared and transmitted to the town board members an additional proposed definition for an owner-occupied contractor yard to be added as a principal, secondary, or accessory use within the RA zoning district.
That would be a separate local law.
So these were, we're reading from the background of proposed transportation terminal local laws. And that's notes from an October 15th, 2025 town board workshop to discuss the proposed local law. So this draft local law we have is not dated, but it would appear that this does not reflect those additional items. The tentative definition for owner-occupied contractor yard, as we have it here, is a portion of a lot used to store and maintain construction equipment and other materials and facilities customarily required in the contractor's trade, but excluding the storage of materials or equipment for off-site sale. The owner of such business activity must reside on the premise. Exterior evidence of an owner-occupied contractor yard may include one or more of the following: a sign, exterior dumpsters or waste receptacles, stored vehicles or vehicles or equipment directly related to the business activity conducted on site. The minimum lot for the owner-occupied contractor yard shall be blank acres. That has not been defined in this document.
Have you received anything additional from the town attorney on this?
Not to my knowledge, and just to clarify, Mr. McGuire, are you reading from this document? It says background to potential new zoning definition.
Background to proposed transportation terminals local zoning.
Yeah.
Okay.
It's the same.
We have a new doc, yeah.
It's the same definition. I just wanted to make sure.
All right.
So that, I thought maybe I had something else. As long as we all have this one.
We have multiple things. The background to the potential new zoning definition, okay.
So other than that, to answer your question, no. I personally, I can't speak for your normal counsel, but he has not transmitted anything else.
So my opinion, the current definition of transportation terminal, that's within our zoning codes, which again is railway terminal, freight station, container terminal or yard, multi-purpose cargo terminal, port, transfer station, and any similar receiving point. That doesn't seem like an RA type activity, but we're not the ones to make that decision, right? It seems kind of out of line with the uses that are principal and accessory uses that are within a residential agricultural district.
But I can think of a few examples off the top of my head that would affect.
With the owner-occupied contractor yard?
No, I mean, with the definition of a transportation terminal, there's a few businesses that would fall under that.
Okay, that are within an RA zone?
I'm pretty sure they are. I'd have to look at the map.
Do you have any, I don't need specifics, I was just curious what type of business is it?
Like, if someone was distributing fuel oil,
Okay,
something like that,
yeah,
that might be construed as a transportation terminal.
okay.
Yeah, I guess I understand on its face the argument that transportation terminal doesn't necessarily belong in the RA zone, but I mean, if the town board is looking to create a specific exemption for a type of transportation terminal that does fit in the RA zone, I sort of don't understand. I mean, I guess I understand the argument, but I don't understand the argument that we're leaning on, that this is like an oversight. You know what I mean?
Mm-hmm.
I mean, I guess they have some quotations here from a former elected official to that effect, but I mean, it seems like the town board, as far as I understand it, does want transportation terminals in the RA zone. They just don't want a specific type
A transportation terminal.
terminal in the RA zone. So, I don't know. I guess we have to think about how that would plug into the comp plan and what that sort of envisions, but.
And just for clarity, you're bound by those same principles in
Right.
review, the ones I previously read. So it's the same general guiding thoughts.
Right.
Right on point.
Right.
Okay. Anything else?
I'm not real crazy about the actual definition of a transportation terminal, because at the end they add, or any similar receiving point. That's a pretty general, I mean, that could cover a wide range of things. You just say any receiving point, I mean.
Oh, an Amazon warehouse permitted in
Right, I
in
mean,
an
if
RA
you have,
zone?
if you have
It might be now, right?
truck parts delivered, or, it's just, I don't know. It's a, but that's not really the issue, I guess, right now.
Well, I think the purpose of tonight is to discuss it a little bit more and then have some more familiarity with it. So moving forward, when we do have our joint meeting with the town board, we're in a better position to discuss. Andrew, based upon 165-15, our advisory report, that does not need to be made at that joint meeting, correct? It would come after that joint meeting, or do you know?
It would not need to be made then, and based upon the discussion tonight, it's my understanding the matter has not been officially referred to this board because the code states it runs 30 days from the referral. So it would be worth nailing down that date.
We don't have that date yet, so.
So, no, it would not have to be there.
Fantastic, all right. Anything else? I think we're good. Absolutely.
Think.
Yeah. I'll have a lot more tomorrow.
So we'll continue our discussion for the site plan review. Collins, you had some.
So, we always pick on Carver, just because I guess he's up and moving and you see his trucks on the road. So this is gonna apply to the Fabcon, it's gonna apply to cement company, Callahan's, and just apply to all of them.
Yeah, especially if they go back 15 years. That means that whole plant that they just built.
That's what I'm saying, yeah.
That's what I'm saying. That's why I do not agree at all with making this retroactive and going back. It would just, there's a lot of businesses that could be really damaged.
Because you have your zoning map in your book, right?
There might be one
In there. But then you can just see if,
There's one somewhere here. Is it right in front? Like in that.
I'm not knocking you.
oh, no,
No, I'm not knocking you, but
no.
how are you gonna go into these MSHA sites and OSHA sites and these big industrial sites and know?
Yeah, like are you gonna go to Lafarge and be like, show me a record of everything you've done here in the last 15 years?
Right. I mean, you guys gotta think about it.
Yeah.
What I have to do.
Not to harp on the point, but I think operationally as a board, there are other people in town who might want their items considered at some point in the next 5 years. So, going back and looking at every single major, industrial project, I think is not a good use of this board's
Time and resources.
correct.
Yeah, I just.
Yeah.
Like, no offense, I mean, the code enforcer is not gonna know all that stuff. Ain't no way. And they're here, you know what I'm saying? They're here. So who are they bothering here?
Right.
I don't agree with it. That's just a question I had.
Mr. Collins, how do you feel about it being applied moving forward? You said you didn't necessarily disagree with that, or? I don't want to put words in your mouth, I'm sorry. How do you feel about it?
No, well, I mean, especially if, say, we'll talk about Carver again. So, I don't know, we'll have, say, TCI down there, and they move out. Somebody else wants to move in and take over the office, and it's already up, it's already been engineered correctly. Why?
And now they're gonna have to go through this whole site plan review process, and then what happens if it doesn't get approved? Now what? Now does the building just sit?
No, now you sit and you don't have any more
I look at it like, in my opinion, there's a reason why we have an industrial zoning district. Because of the activities that go on in the industrial, I'm not saying that they should be exempt from, the laws of the land, but it's just not
Well, I think they're governed more strict.
right.
That's my opinion, that's just my opinion.
Yeah. Part of the concern, I think, is that some people may look at it that they're not governed or reviewed at the same level currently as other properties, right? If you look at, we had solar applications that are here for a few months. We go through every little nitty-gritty detail and, get approved or don't get approved depending on the application. But if we look at an expansion of an industrial activity that's within the industrial zone, as long as it's permitted, there is no review currently that's happening for that. Right? Jason there's no site plan review for that process currently, correct?
For the solar?
No, for industrial.
Oh.
Right? So solar's permitted, right? It's permitted in the zoning, allows for it to happen, right? We go through site plan review, or we have a business that wants to expand, right? Go through site plan review. But currently in the industrial, if we have an expansion or a new industrial development within that zone, there is no site plan review. So I tend to agree with you. I don't think it's good use of time, resources, or
Correct.
necessarily fair to be looking at this retroactively. I think, my opinion, going forward, I think it makes sense. That way everybody is playing the same field, same level of review. Right.
Yeah.
I'd agree with that. I mean, we're putting the trailer park, they're moving some roads and lots around. So, I mean, I think having industry at the same level, I think, is justified. But, I think in whatever final report or whatever we do, I think special consideration for tenancy, I think, really does need to be looked at.
I tend to agree with you. I think that'd be something we need to include in that report that's going to be prepared. So. We'll get together. It'll be fun. Yeah. Okay. All right.
That's all I got. Bring them back, Trish.
Yes, sir.
Okay, so, there's really nothing else that's on the, agenda. Jason, where is this Lois Realty? Where are they sitting right now?
I just talked to Aaron Monday, and he is almost done with his site plan review maps.
Okay, getting updated maps
Yes.
and all of that stuff to present.
He is almost done with all the drafting.
Okay, perfect.
So potentially, I would say that he would be here on the 12th.
Okay, and as, I wish I had an answer for all of you as far as that first and third Thursday. It's really like in limbo, not being on that board yet, and not being able to sit and have discussions with them because I'm not a part of it and they can't, So I don't think I'll have answers for you until January 1st.
So the first Thursday of the month is January 1st.
Yeah,
So
I
is
can
it safe to
definitely
say
say.
we're not gonna be meeting on January 1st?
I'm safe to say yes. That's our reorganizational meeting anyway, so it wouldn't happen. Fair point. So, but going forward, as soon as I know. Now, I just want to share, I probably put Mr. McGuire on the spot. I always put Al on the spot as far as asking, hey, will you guys chair? And I feel that anyone that sits here is qualified to do it with their experience and stuff. I did ask Mr. Boomer, and I said that would be my recommendation, and he accepted. So it is up to the new town board as far as who they're going to. Yeah, I just, it's been an honor and a privilege to sit here with all of you. It bothers me so much because I feel that we have such an amazing board and we all work well together. And I'm going to the town board where I just, it's new. And so I want to thank each of you because it truly has been an honor and a privilege to sit here. And I've learned so much. We all have brought so much to this board. And I just wish all of you the best of luck and hope that the board continues to work as cohesively as we all have. And Jason, the same thing. You've been great to work with. So thank you for that.
You got the axe?
So this is my last official meeting, so I guess I will make a motion
Wait a
to,
minute, did we make a decision on the old business and new business, or we gotta just think on that?
Nate, that's gonna be your problem. Jason's gonna be your problem, he's tough. I think it's in the best interest to redo that. And Jason knows, he can say, I've gone round and round with him over and over, and so has Bill with him, to try to clean this up. So my recommendation, Jason, would be do something that works for you, but makes it cleaner for this board and the public.
We can sit down and talk about it some more, come up with some ideas, exactly how we want to say it.
Yes. Well, it's been a pleasure working with you, and I know how much effort you have to put behind the scenes too. Yes. So, thank you very much. And I only get to see you once a month instead of twice. So thank you.
Well, as long as you behave.
Thank you for only once a month.
He's really looking forward to that, he's so happy. Get rid of this woman once a month now. No, and I'll probably still be working with you, just not as much, so.
Will you be the liaison to the planning
I
board?
was just gonna ask that, yeah. Hopefully.
No, I don't mind. I don't know what the board's intention is yet. And I think we're all gonna be learning, come January 1st. But I will definitely always reach out. Every time we leave a meeting, I always go and do a synopsis so that I have records for myself. So if you guys need anything in reference to any previous cases or anything, by all means.
We still gonna keep Mr. Bill for council?
I keep saying I wanna bring him to my side now.
No.
You guys are in amazing hands with Kennery, his law firm. I work closely with Bill. I have to call him for any little thing, and he's amazing. And he sent Andrew, thank you so much for tonight. You were extremely helpful. So
Big shoes to fill, but happy.
yeah, so thank you. But yeah, I think we'll be working with Bill, especially going forward. It seems like the town board is going to be working more with the planning board, which we haven't done that much. So I think we'll still be working together on different levels, but I don't think it's really weird because this is ending for me, but I don't think it's really goodbye. I think we're actually going to be working together more.
Oh, jeez.
It's quite weird. So.
Camera.
But one last time, I will make a motion to adjourn this meeting. If nothing else?
I'll second that.
All in favor?
Aye.
Everybody have a Merry Christmas.